Hi, good morning. Sheila Sloan, Susan Boggs here. Thank you for joining us. We are very blessed to have Jason Hudson from U.S. Department of Labor Region 5 in Chicago to present this to us today. He will not be able to address specific Illinois, IWDS entries or that type of thing. We've sent out some information previously, and Sheila's going to have some training in August. So please try to limit your questions to just specifically, the federal, the new regs and that type of thing. And you can email us separately and we will get back to you individually or as a group if we feel we need to. So with that, welcome Jason Hudson.
If you have questions, make sure you put them in the chat because I think everyone is muted at this point.
Yeah.
So.
Well, thank you. Thank you to everybody for joining today. We're going to talk a little bit about reversion. And to kind of give you some comfort, this is my first complete reversion. So I started with the Department of Labor in 2015. So I caught the tail end of the last reversion we went through, reversion 2014. But it should provide you some comfort that this is reversion 2021 will be my first complete from start to hopefully finish. So, reversion, it sounds like the program is going away. That's false. Trade is still a program. It still exists. Reversion just simply means that we are kind of reverting back to a previous law. So if you guys have been dealing with the TAA program, for the past few years, you will know that there are several laws that kind of govern TAA. So you could have the 2002 law, you could have the 2009 law, 2015. For some petitions, you could even have back to 1974, which was the first TAA, act that came out. So that there can be different laws, and that's kind of what reversion is. It's just reverting back to an earlier law. So we're just going back in time a little bit, but to just reaffirm, reversion does not mean that the TAA program is over. It doesn't mean that it won't exist. There are sunset provisions that will occur later this year, but there's several bills in Congress that are addressing the TAA program to hopefully make it a little bit more robust, a little bit more bulky, and provide a little bit more. So, with that being said, what we're kind of going to talk about today is, reversion. What does that mean? What does it look like? What will you have to do when you have a TAA customer come into your office, or if many of us are still virtual, if you do a web chat with them, what does it look like as far as administering the program? And it's going to be a little bit different. It's not going to be entirely different, but there will be some things that will be different. And the reason why it's important is, I grew up in Illinois. I'm an Illinois kid, Southern Illinois, and I grew up around Belleville, Illinois. And if you are familiar with that area, you know that there is the steel plant down there, it's Granite City Steel. So, I'm familiar with the TAA program, and I have, several family members that have worked at those plants. And the reason why I bring that up is because with TAA, you may be aware, especially if you're in the locals, workers talk to each other, right? So you may have workers that qualify under the 2015 program, and they may tell one of their coworkers, one of their colleagues, hey, there's this TAA program. You should go into your local office and see what it's about. But that doesn't always mean that the next coworker will also qualify under the 2015 program. And that's the reason why reversion is important, is because you will still need to administer the 2015 program to participants that are eligible, but you'll also need to administer any reversion petitions completely different, even though both of those workers may work at Granite City Steel, or they may work for the same company. With TAA, it's all about the worker group and it's all about the petition, right? So just because you work at a specific company doesn't mean you'll always fall under a specific petition. And that's going to be very important for a reversion. is just because one company has been certified, that one company could have several different petitions, and it's going to be very important to make sure that you know which law that they fall under. So we won't touch too much on 2015, 2011, and 2009 law today. We're just going to really talk about reversion and what that may look like if you have a participant coming to the office. Now for reversion 2021, the most important date for reversion 2021, is July 1st, 2021. And the reason why that date is important is because that is the date that the reversion occurred. So for any petition that was filed before or on June 30th, midnight or before, will not fall under reversion 2021. Any petition that is or will be filed July 1st, 12:01 a.m. going forward, and until Congress potentially changes some things, will be considered a reversion petition. So I'm not sure if Illinois has filed any petitions so far under reversion 2021, but the most important date that you need to remember for reversion is July 1st, 2021. So if you have participants that you were already serving, under TAA in your local office or at the state level, you will continue to serve them under like normal, just as nothing ever happened. Reversion is only going to kick in from July 1st going forward. Okay, and that's kind of what we're going to talk about today. And I believe Sheila and Susan are working the chat room. So, put your questions in the chat room. We'll try to address as many as possible during the presentation. If not, we can always circle back via email, or Sheila and Susan are always available via email as well. But if you have any questions, please put them in the chat as we go through. But again, just to frame this presentation today, we are not talking about participants that you are already serving under previous laws. We're only talking about participants that you may service under reversion 2021, and that starts from July 1st going forward. So what is the source? What, do we give you instructions? Do we give you like direction on how this looks? Or do you always have to come back to this presentation and, look at my shirt? I didn't get a chance to iron my shirt today, so you may see some wrinkles, but if you want to come back and look at the wrinkled shirt in this presentation, you can. But you can also go to Teagle 2420. And Teagle 2420 is going to give you the operating instructions for reversion. Within that Teagle, there's several charts that kind of give you a comparison and contrast between previous laws and reversion 2021. So we try to break it down and simplify it to what you can and cannot do. But sometimes those Teagles don't always answer every single question that you may have. So again, please reach out if you need anything. But if you just want the operating instructions, the documentation is going to be Teagle 24-20. So what are we going to talk about today? Well, what are the objectives of the training? We're going to give you a little bit of background. We're going to talk about the benefits and services and how they may change a little bit. Group eligibility. There will be some changes on who is eligible and who is not eligible under reversion 2021. You'll see that the eligibility is a little bit more restricted compared to previous years. So those would be the objectives. Acronyms, you guys probably have seen several of these acronyms. ATAA is similar to RTAA. ATAA is kind of the predecessor. The Court of International Trade may be a little bit foreign. That's just an alternative way that we can certify petitions. PEARL, depending if you are involved in reporting and data, you may be familiar with the PEARL report. But the IEP, that should be pretty familiar. Teagles, TAA, obviously UI, many of these acronyms should be familiar. So we will kind of jump right into the background. So reversion, right? I'm not a legislator, but the way that TAA comes into implementation is through the act. It comes through a piece of legislation enacted by Congress, right? And sometimes those pieces of legislations, those documents have provisions that require the program to sunset on specific dates. They have specific provisions that require the piece of legislation to end or expire by a specific date. Now, again, as I mentioned earlier, the TAA program itself does not expire on July 1st. It did not expire on July 1st. It's just that certain provisions under the TARA Act, the TAA Readjustment Act, expired on a specific date. And that was because Congress placed that in the piece of legislation. But it's very important to remember that TAA still exists. And participants that were in the process, that were receiving training, that were participating and had a petition or a certification prior to July 1st are still in existence. Reversion doesn't make that a go away, right? The regulations that will still apply is 20 CFR 618. You will know that we've been working on regulations for the past several years. And you will know that those regulations are fairly new. They came out in fall of 2020. And with those regulations, many of those regulations will still apply unless Reversion 2021 specifically impacts those regulations. So don't completely disregard or discard the new regulations that were just implemented because many of them will continue to apply. Unless there are a few, points where Reversion 2021 will kind of conflict and may, supersede the regulations. But for the most part, the regulations at 618 will continue to apply. So again, just a background, TARA, it has sunset provisions. And some of those sunset provisions require certain pieces of the legislation to expire at certain periods of time, but it does not expire the TAA program itself. So group eligibility. I mentioned earlier that, under reversion, some individuals will be eligible that were not previously allowed to be, and some individuals will not. With group eligibility, I guess the first thing I kind of want to mention is if you have a petition that you believe may be impacted by TAA, please continue to file those petitions, even if you believe that they may not qualify under the new, Reversion 2021. And the reason why it's important to continue to file those petitions or to direct those petitions to whoever may file those petitions is because in the previous reversion, we were able to go back and retroactively reconsider past petitions that were denied. So if you had a petition and it may not be, it was denied under Reversion 2021, and depending on how the legislation changes or depending on the actions of Congress, we may be able to go back and retroactively consider those petitions. So please continue to file any petition or direct the petitions to whoever files those petitions, even if you believe that they will not be certified. Now, there have been some changes in group eligibility that are, fall under Reversion 2021. You'll see that there's been shifts in production criteria. We have different criteria that we consider now before we will certify a petition. We will consider secondary certification that's conditional. We will no longer have the International Trade Commission based certifications. But again, with the group, the most important with the group eligibility is that please continue to file the petition. You'll see that certain countries, due to certain trade agreements, may not be allowed under Reversion 2021, but that doesn't really affect our major trading partners. So China, India, those petitions are typically still will be allowed under reversion 2021, but we do have certain trade agreements that will prevent certain certifications from being certified. So, petitions, right? So who can file? Same as usual. There hasn't been anything that has changed with this. You have the state agency, which I believe Susan and Sheila do many of the petitions. You can have the One Stop, which is the local AJCs. You can have rapid response staff. You have unions. You can have employers. You can have a duly authorized representative. And the fourth bullet point is important. If you've been around TAA for a while, you know that it used to be 3 workers, but it only needs to be a group of 2 workers. So it could just be a worker and their colleague now that can file a petition. So there hasn't been too much that has changed with the actual filing of petition. Pretty much anyone can file, and we ask that you continue to file those petitions, even if you believe that they will not be filed or will not be approved under reversion 2021. Here's the contact information, how you will file. Again, not too much has changed here. We have the email, taa.petition@dol.gov. You can always send it to snail mail if that's the case. And you can always use our website, which is preferred. Again, reversion 2021 only applies to petitions going July 1st and forward. Okay, so if you had a petition that was filed June 30th or before, they will continue to fall under the previous law. So what are we looking for with quality petitions? Well, we're looking for the location of the impacted group. We're looking for the type of work. This is going to be really important under reversion 2021, is specifically what type of work were the workers doing. And the reason why this is important is because, again, there are certain restrictions with certain trading partners that come into play under reversion 2021. So it's very important that we know what type of work was being conducted by the workers. As normal, we need the company contact information, the email address, and if there's any type of subdivision, especially with larger companies, it is nice to know that, hey, this person was working at the Springfield, Illinois plant, or they were working at the, Chicago plant. If you can identify the subdivision, but most importantly, please try to specify what type of work was being conducted. So certification criteria, as I mentioned earlier, there is a shift in production, that deals with reversion 2021. There are certain foreign countries that reversion 2021 does not allow us to certify. That again, it doesn't affect our major trading partners, which is China, India, Europe, the UK. Those trading partners will most likely not be affected, but there are some trading partners that will not be allowed to will have an impact on whether or not a petition is certified. The International Trade Commission is no longer a path to certification. The International Trade Commission is a specific entity that they can make a certain determination about foreign trade, and depending on those types of determinations, it may allow TAA an easier path to certify a specific petition. The alternative trade adjustment assistance, you will see that is specific to reversion 2021, and we will talk about that, I believe, in a few slides. And again, if you have any questions, I may be moving too fast, but if you have any questions, please put them in the chat. And Susan and Sheila, if you have any questions, please feel free to jump in, and we will make every attempt to address them as we go. So the certification criteria, that we have 2 primary paths to certification, which are a shift in production, which is now conditional, and increased imports. We also have a secondary path to certification, which includes upstream suppliers and downstream producers. these are also conditioned and different before. So you have two different types of paths. You have a primary path, which deals with the shift in production, meaning that the product or service has now moved overseas, or there's a secondary producer or supplier that has been affected by the shift in production. So those are the two paths to certification under Reversion 2021. So with the current law, you have RTAA, which is the Readjustment Trade Assistance Act, and that is for our workers that are 50 years of age or older. ATAA is very similar. However, it is a little bit more restrictive than RTAA. With ATAA, it's not a separate petitioning process. When a petition is filed on behalf of a group of workers, utilizing the website, you're filing for TAA and ATAA. So you do not need to file a separate petition for ATAA, meaning, when you file a petition, it's not a separate filing process. So when we make our determination, it's a dual determination, meaning if you are certified under TAA, you will also be certified under ATAA. Now, under reversion, RTAA is no longer a benefit under reversion. The only benefit allowed is ATAA. And the reason why that's important is because RTAA allows you to have training associated with work. So if you're familiar with RTAA, you can work full-time and receive the RTAA benefit. You may also be able to work part-time and attend training full-time and receive the RTAA benefit. So that is a difference between ATAA and RTAA, but it is important to remember that RTAA is not available under Reversion 2021. So what is the criteria under ATAA? Well, the worker has to be age of 50 years or older. The worker in the firm must possess skills that are not transferable. So essentially, that worker is 50 years of age or older and does not really have a transferable skill that the state identifies. And the conditions within the worker's industry are competitive. So they're adverse. Maybe it's difficult for that individual to obtain employment within their industry. This is a evaluation conducted by the state. But the most important thing off this slide is to remember that RTAA is no longer a benefit under Reversion 2021. It only goes to ATAA. So what worker groups are eligible under Reversion 2021? You will see that not only are certain types of workers eligible under Reversion 2021, you will also see that certain types of products and services are available under Reversion 2021. So if you look in the last two columns, prior to July 1st, 2021, you will see that articles, a shift in production for articles, as well as producers that are affected by a shift in production of articles, are both permitted under Reversion 2021, as well as the 2015 law. What you will see that there's a difference in services under Reversion 2021. So under the 2015 law, we may be able to certify a petition for workers that were providing services. So think of call center employees, accountants, maybe consultants, maybe IT services. Under 2015 law, those types of petitions can be certified. Under Reversion 2021, services are not allowed. So if you have a call center worker group that goes overseas that is affected by foreign trade, Reversion 2021 unfortunately would most likely not be able to certify a petition that deals with service sector employees. So articles, you're looking at something that's tangible, producing a truck, a tire, bolts, a computer. You're looking at something that's actually being produced, whereas a service, there's nothing really tangible that is being produced. It's more of, an intangible service that's being produced, such as a call center that was affected by foreign impact. You can see that there hasn't been anything that's changed with public sector employees. So under 2015 and reversion, public sector employees would not be an eligible worker group. You will see that the International Trade Commission based petition that has changed as well under 2015. Previously, if the ITC would have certified a certain type of article or service as affected by foreign trade, typically TAA could take that determination and institute a certification under the TAA program. That is not the case under Reversion 2021. We cannot or we would not accept a determination by the International Trade Commission. 2015 law, we kind of touched on this a little bit earlier. There are certain trade agreements in place. With 2015, the shift in production could pretty much go to any country, and we would just look to see whether or not there was a change in production. Under Reversion 2021, it is limited in where the shift of production could have occurred. So, if you have an employer in Springfield, Illinois that was producing a widget and that widget has shifted to a specific trading partner, depending on which trading partner it is, we may not be able to certify them. Again, it does not affect our primary trade partners for the most part, and that's, India, Europe, China. So you shouldn't see too much of a change with that, as those tend to be the primary, trading partners that kind of deal with the TAA program. But it is important to know that there are some limitations now that deal with the shift in production and depending on the type of country. So ATA group eligibility. Under 2015, ATA is not in existence. It's RTAA, but under Reversion 2021, it reverts back to ATA. And at the outset, I kind of spoke about, that's kind of the important thing about reversion is that, like I said, it doesn't mean that the trade program is no longer. It just means that certain benefits and services have changed. And one of those benefits and services that have changed is ATA. So if you have a worker that was working for the same company and, one worker's petition was certified on June 30th and another petition was filed on July 1st, one worker may be eligible for RTAA, which provides a much more robust level of benefits and services, and one worker that was working for the same company, possibly even doing the same type of work, may only qualify for ATA. And the primary difference between RTA and ATA is that RTA is a little bit more flexible as far as allowing the worker to attend training. ATA does not permit any training. You have to essentially obtain reemployment, and then a wage subsidy is provided based on that new reemployment. So employment and case management services. The kind of big topic with employment and case management services under Reversion 2021 is the funding for employment and case management services is no longer available. And with that being said, the state still needs to provide case management services. Now, that does not include initial assessments. So the funding is still available to provide an initial assessment for a TAA worker. However, ongoing case management and any other type of case management services, the state is still required to provide those services, those case management services. But unfortunately, under Reversion 2021, the funding is not available to assist in providing those services. So what this is going to require is going to require a lot more collaboration between partner programs such as Wagner Pfizer and WIOA, because there is an expectation and requirement that the, case management services are still provided. But as I mentioned, the funding to do so would not be available. Again, this only applies going from July 1st going forward. So if you have workers that have a petition before July 1st, the funding principles are still in place. And as you are aware, with case management funding, it's a very flexible and broad tool that you have at your disposal to assist a participant. That level of service is still expected. It's just that now you will have to locate the funding from a different partner program. And again, this does not apply to the initial assessment. So I'm not exactly sure how Illinois conducts their initial assessment, but some states have certain processes in place where they may accept educational degree, they may accept a certain vendor that provides an initial assessment. Whatever Illinois uses as their initial assessment, the funding is still available to allow you to conduct that first assessment to see what the individual is capable of, or what deficiencies that you may need to address. But anything after the initial assessment is when when you will need to start bringing in partner programs. This is probably, there's a lot of things that happened in the reversion, but this is probably one of the biggest items that will probably, likely affect you on a day-to-day basis, is that you will need to engage your partners to still deliver the services, because it is the expectation. And we kind of talked about initial assessments. Again, this is just a little bit repetitive, but again, you can provide an initial assessment with TAA funds. And under Reversion 2021, it's still a requirement that those initial assessments are still provided. So I'll pause to see if there's any questions so far. And if not, we can continue to move forward.
No questions so far, Jason.
Okay. All right. So let's see. We are other employment and case management services. Again, there's an expectation that employment and case management services are still, provided to workers, even though, the funding has changed a little bit. So comprehensive and specialized assessments, IEPs, post-employment follow-up services, this will most likely require engagement of your WIOA partners, your rapid response partners, but rapid response, I'm not fluent in rapid response, but rapid response is a very good resource that you may want to tap into. They have considerable amount of funding, and rapid response funding is almost as flexible as TAA case management funding. So you can provide a lot of services under rapid response. And that is likely where many states will fill the void, during reversion, is through their rapid response funding. WIOA, is always a resource, but WIOA sometimes has limited funding to provide the level of service that a TAA participant may need. Always, consider your rapid response partners. You have your dislocated worker grants. Those are kind of specific to certain objectives, but dislocated worker grants may be available, Wagner-Peyser as well. But again, the takeaway is there is an expectation that the services are still provided. It's just going to be, a kind of a hunt to locate the funding on how to provide those services. So co-enrollment is still required, for TAA participants. And that's a co-enrollment with WIOA. Like I said, many things changed under reversion, but one of them that did not change is that co-enrollment is still required. There's still an expectation for co-enrollment, and it's still a requirement that the state co-enrolls an individual unless they opt out. So unless the participant is opting out of co-enrollment, the workers should still be co-enrolled. And this is going to be a challenge, primarily because there's no funding to kind of, promote why should we co-enroll if we don't necessarily have the funding to do so. Again, that's an unfortunate consequence of reversion 2021. But if you don't go enroll, you run the issue of having some reporting issues. And as Sheila mentioned, Illinois is doing very well with the co-enrollment. So you don't at 98%, which is the highest in Region 5, the last time I checked. So you don't want to allow that number to slip, because one, you all are doing very well at co-enrollment. And I believe it used to be 99%. So it's good we want to actually get that back up. And I know at one point, Illinois has always been a leader in co-enrollment. So you don't want the reversion 2021 to kind of impact that and reduce your score. The goal is 75%. You guys are far above that. But most states kind of hover around 40 to 50%. So you guys are doing considerably better than your other counterparts in Region 5. But again, not to harp on it, co-enrollment is required. It is expected unless the worker opts out of co-enrollment. Rapid response. We know rapid response. I know we have quite a few individuals on the call, so we may have rapid response on the call. Rapid response is probably where a lot of these services can be provided for TAA participants under reversion 2021. With rapid response, it's required for the trade program once a petition is filed. And sometimes this is kind of lost, where rapid response doesn't always reach out to the trade participant until there's an actual certification. Under the TAA program, rapid response services need to be provided as soon as petition is filed. And that's even the case, if it's only 2 workers. We kind of started off with you only need 2 workers to file a petition now. And rapid response tends to happen when you have larger certifications, maybe 50 workers, 100 workers, a couple, 300 workers. Those are not the cases where rapid response does not occur. Typically, where we see rapid response not occurring is when there's 5 workers, when there's 2 workers, when there's 10 workers. But the requirement of the TAA program is that rapid response is required as soon as any petition is filed. And that's regardless if it's ever certified. And that's regardless if you are very familiar with petitions and you kind of see the trend in how petitions are certified. Even if you don't believe there's a high chance of their petition being certified, TAA still requires the state to provide a rapid response service as soon as the petition is filed. Employment services, again, we kind of touched on this a little bit earlier. Where can you seek help? If the funding has kind of dried up under reversion 2021 as far as case management, where can you go out to seek help? Well, you have Wagner Pfizer. You can get counseling, assessments. You can get LMI information. You have WIOA. Again, the co-enrollment is required. You can also get counseling, LMI information, supportive services, dislocated worker grants. These tend to be very specific, depending on certain objectives. In the past few years, there's been several dislocated worker grants dealing with opioids. So you may be able to access those grants. Again, those are generally very specific to a certain objective. So, TAA workers may not always qualify for a dislocated worker grant, but they are a resource, and you kind of want to still make sure that you utilize them. Rapid response funding is a very flexible funding source that would allow you to continue to hopefully operate at the same level of service that you currently do with TAA participants. So job search allowances and relocation allowances. Reversion 2021 does not have an impact on either the job search allowance or the relocation allowance. You have the job search allowance, which you all know is 90% of the allowable costs, up to $1,250. It can be multiple trips. And in recent years, the interpretation of what is a job search has been loosened. It's very broad. So job fairs, I know many employers are doing virtual interviews right now. So if there are costs associated with, possibly downloading a specific app to do a certain type of interview, that could possibly be considered. Again, I would make sure that the state that if there is a policy within the state about virtual services for job search allowances, make sure you abide with that. But it is a very broad category, and it continues to become even more looser as far as what qualifies as a job search. So job fairs, like I said, virtual interviews. With the job search allowance, it's important to remember when you are providing this allowance to the workers that it is up to $1,250. So you want to make sure that the workers are aware of that, and you want to make sure that they are not trickling off $200 here, $300 here. And it turns out that the actual dream job is in Florida, and that costs $1,000 to go to, and they've already used $500-$600 on maybe some job search activities that weren't really the ultimate goal. So job search, it is limited and it is capped. But under reversion 2021, that is not changed. Relocation allowances still the exact same, 90% of the allowance relocation costs, plus up to the $1,250 in a lump sum payment. Again, this is all the same for job search and relocation. There hasn't been any changes under reversion 2021. So here's just a chart again to kind of just break it out a little bit more. You can see the changes over the years. If you have a participant under the 2009 program, you will see that that was probably the best year to kind of participate in the job search and relocation activities. But again, this chart kind of also again re-highlights that what reversion is essentially is just saying that, hey, there's several laws in place, right? Reversion does not mean that the TAA program has expired. Reversion just means that now there's a 2002 program, the 2009, the 2011. Reversion 2014 was essentially, overruled by 2015, but technically there's the reversion 2014 program. There's the 2015 program that many of us are familiar with. And now there is the reversion 2021 program. And if Congress acts or makes any changes, you'll probably see a separate column that will hopefully combine all of these laws into one. That's what several bills are proposing, so that we don't have to administer several different laws. But I hope if there are changes, you'll see that there will be an additional column that will hopefully address reversion 2021. But this chart alone, it deals with job search and relocation. But this chart alone kind of provides a bigger picture that, hey, we have 6 laws technically under the TAA program. And sometimes that makes it a difficult program to administer. But, as we move forward, you'll see that you have lesser and lesser 2002 participants, 2009 participants. A couple of days ago, there was a state that had a participant from the very first law from 1974. So with the TAA program, unless something changes, TAA, the actual training services are a lifetime benefit. So unless Congress changes that, the participant, once they become eligible, continue to have a lifetime benefit as far as training and a few other services. But the 2002 participant, again, unless something changes, can come 10 years from now and continue to access a training plan if they need so. And that's one of the benefits, but it's also one of the challenges that you all have in kind of administering the program. So training, we kind of talked about job search and relocation. There weren't any training changes under reversion 2021. For training, there are a few changes under reversion 2021. And this is where we kind of spend the bulk of our time under TAA. And I know with the new regulations, Illinois made some changes to kind of, I believe, to how the training plans are approved and what happens at the local level, what happens at the state level. This is where we spend the bulk of our time. Training funds can continue to be used to create supplemental, customized group training, English as a second language, remedial education classes. For English as a second language, it's always important to remember that you, as frequent as possible, you want to try to partner those English as a second language courses with an occupational goal. Now, it is important to, that's not a requirement. It is not required that you partner English as a second language with the occupational goal. But whenever possible, you always want to try to explore that as a possibility for the participant. It should never be, we should never want to limit a worker to a specific type of training unless that is their choice. And if it is their choice, that's fine. Just make sure you try to document that you have explained to the worker that they do have alternative options. But again, we can't force a worker to participate in certain types of training. We just like to see that when you are engaging with the workers, that you have explained to them that, hey, there are alternative options. But again, you don't have to force anyone to do anything. You don't have to force anyone to take up a specific type of training. If English as a second language is their only decision or choice or selection, that is completely fine with the Department of Labor. Just make sure that we, as a case management practice, start to document that alternatives have been explained. For part-time training, that is allowable under Reversion 2021. And some may think that this is, excuse me, that this is new, but it's not that part-time training is new. It's that part-time training is now, TRA is now allowed to be paid with part-time training. So even under 2015 law, that's the most recent law, a worker could go to training part-time. I think most training institutions require 12 hours. So say a worker goes to training for 6 hours, that's always been allowable. However, the state has not been allowed to pay TRA for part-time training. Under Reversion 2021, that is a significant change, right? So, for petitions that are filed for July 1st and afterwards, that it's a pretty big change that if a worker comes in and they want to engage in part-time training, not only can they continue, engage in part-time training, but TRA is now payable for part-time training. And I'm not sure if we have any UI or TRA individuals on the phone, but this is going to require, probably changes in your system, but it's also going to require kind of a change in the mindset that we can't deny TRA or we cannot exclude someone from TRA simply because they want to engage in part-time training. Now, there are other provisions that encourage the worker to complete training as soon as possible, in the shortest period possible, so they can obtain reemployment. However, it's just important to note that you cannot deny TRA simply because the worker chooses to engage in part-time training. That is allowable under Reversion 2021. Training, it can always include multiple types of training. This hasn't changed. So you can have on-the-job training, you can have classroom training. With apprenticeships, nothing has changed under apprenticeships for Reversion 2021. So that will also continue to operate like normal. You can always continue to amend training program. Distance learning is still allowable. So really the training on the 2020 Reversion 2021, the biggest change to kind of make note of is that the part-time training is now allowable and TRA can be paid on part-time training. Work-based training under Reversion 2021, Reversion 2021 kind of goes back to, earlier versions of trade kind of promoted work-based training. So again, I started in 2015 with the Department of Labor and kind of the promotion of what type of training to for the worker to take up sometimes was geared towards a classroom training instead of a work-based training. Work-based training is essentially like an OJT or an apprenticeship, where the worker actually goes to, the employer, or they go to the training institution and they actually complete the work on site. So if you have a welding facility for an OJT, that worker actually goes to the welding facility for, up to 104 weeks, actually welds and learns on the job, versus a classroom training where the worker goes to the University of Illinois and sits in a seat and learns about the theories of welding. Under Reversion 2021, work-based training is actually the preferred method of training. And this is a little bit different than previous laws. It doesn't mean that you only have to place an individual into a work-based training program. It just means that it is the preferred method of training. When you are approving training plans, you want to kind of take note of that when you're looking at those 6 conditions, whether or not the training is suitable, whether or not the worker would benefit from a specific type of training. Take work-based training into consideration as the preferred method when you are approving those 6 conditions. But again, it does not mean that a worker can only be approved for a work-based training. Again, with the apprenticeship, there hasn't been anything that has changed under Reversion 2021 for apprenticeships. Everything is the exact same. You can receive up to 130 weeks. And with the apprenticeship, sometimes, just to kind of give a background on an apprenticeship, I'm not sure. I believe, only have a handful of them in the region right now, but and Illinois may or may not have one. But an apprenticeship is kind of the best of both worlds. You get on-the-job training, but you also receive classroom training. And not only do you receive both those types of trainings, it can potentially be registered, right? So if you receive a registered apprenticeship, that's essentially a credential that is recognized through all the states and territories, meaning if you complete an apprenticeship in the state of Illinois, it will be recognized by an employer in California or an employer in Florida, right? It doesn't mean that simply because you completed on-the-job training in Illinois that it wouldn't be recognized anywhere else. And the distinction between an OJT and an apprenticeship is that an OJT, the worker is still a trainee, right? They're going to this training facility, most likely it's an employer. But with an OJT, it's not really recognized outside of that training institution or that employer, right? So if Jason were to go to a welding facility and conduct a 52-week on-the-job training, he could learn about OJTs, and hopefully that employer would then provide Jason a job once he completed his OJT. But if for some reason that employer did not offer employment following OJT, then unfortunately that OJT experience would not be recognized as registered, or would not have a specific credential attached to it that would move with the worker. The difference with an apprenticeship is they do have a credential. They can move from California to Florida to Michigan, and that credential will kind of follow them. But from this slide, what you want to take is that work-based training is the preferred method of training, and you need to take that into consideration when approving the 6 conditions. So here's just a chart of the allowable weeks. You will see that much has not changed. In fact, nothing has changed, right? So 2015, you have 130 weeks. That's still the maximum amount of weeks that are allowed. And you will see that part-time training, again, it was a misbelief that part-time training is not allowed under 2015. That's incorrect. Part-time training is allowed under the 2015 law. However, under the 2015 law, TRA cannot be paid for part-time training under the 2015 law. That is different from Reversion 2021, where part-time training is allowed and TRA can be paid on part-time training. The breaks are still the same, so 30-day breaks. Remedial training is still allowed, and online training is still allowed as well. So ATAA, we kind of touched on this a little bit earlier. Group eligibility, remember, it's just those, it's part of the petition and investigation process. We do have new petition forms for ATAA, which are on the website. So if you go to dol.gov, the new forms are available. We will be asking the firms for the age of the workers and the transferability of the skills of workers. And remember, it's just those 3 requirements. They have to be 50 years of age or older. There has to be a they have to lack transferable skills, and they have to have an adverse impact on obtaining employment in their industry. The biggest difference between ATA and RTA is it cannot be combined with training, right? This is a really big disadvantage for workers that will fall under reversion 2021. Under RTA, you can combine RTA with training. So the worker can go to full-time training, they can go to part-time training, and they could potentially still receive the RTA wage subsidy. For ATA, the Alternative Trade Adjustment Assistance, training cannot be combined with ATA. So essentially, in order to receive the ATA benefit under reversion 2021, the worker has to obtain employment, full-time employment. It's also important to remember that you cannot receive ATA after TRA, and you cannot receive TRA after ATA. And those are pretty much the same principles under RTA, but the biggest thing with ATA is that training is no longer allowed to be partnered with ATA. So again, another friendly chart to kind of show us a compare and contrast. Under 2015, full-time employment is allowed. You will see that the biggest or the first change under reversion 2021 and 2015 is part-time employment. 2015 allows part-time employment with full-time training. Reversion 2021 does not allow part-time employment unless there's multiple jobs that equal full-time employment. But essentially, you have to have full-time employment under reversion 2021. We just mentioned this, training and RTA under 2015, you can combine both of them. Under reversion 2021, the only thing available is the ATA benefit. The maximum amount is still $10,000. And you can see that the deadlines for reemployment under 2015, you will see that there's a 104-week period that you have to qualify and claim. That is significantly shorter, about 6 months under reversion 2021. So there's a shorter time frame to receive ATA under reversion 2021. TRA. So we do have enrollment deadlines. This will be a really big change for under reversion 2021. However, there hasn't been any change in weeks. So right now, we know TRA with the waivers, there's no change in waivers. You still only have the 3 different waivers. That's health, enrollment is not available, and training is not available, right? So those are still only the three types of waivers that you can issue. The biggest change with TRA is that right now we have 26 weeks from the last date of separation, or 26 weeks from the date of certification, in order to place that individual into a training plan before we have to issue a waiver. Those deadlines are significantly shorter under reversion 2021. And the reason why this is important is it's going to place, unfortunately, a burden on you all to either place these individuals into a certain type of training within a very short time frame, or to have a waiver issued in a very short time frame. So just because the deadlines are shortened, it doesn't mean that the worker has to be in a training by a certain period. We always want you to place them in the best type of training as possible. It's just that now you will have to issue a waiver much quicker than you had to do under previous laws. And the burden comes in because, as you know, with waivers, there's a lot of requirements that flow from waivers. You have to review the waivers. You have to get them approved. You have to revoke them. You have to send out a notice when you revoke them. So that's the unfortunate part about waivers, is that you have a shorter period to place the individual in training. And right now we're approaching the fall semester for many training institutions. So you shouldn't run into too many options. But the 8-16 week deadlines start to present problems when you have layoffs in October and November, kind of in the middle of a academic semester, and the next academic semester doesn't start until 20 weeks later or 30 weeks later. That's when the 8-16 week deadlines really start to play a factor. So with the TRA, the number of weeks available is still the exact same. You still only have the same 3 types of waivers. That's health, enrollment unavailable, and training unavailable. But the deadlines for for actually enrolling or waiving the individual from training have reduced significantly. As far as a bona fide application, this is new under reversion 2021. You must file a bona fide application for training within 210 days of separation or certification for additional TRA eligibility. So if you have a worker that kind of just sits and sits and sits, hoping for a recall or maybe just enjoying an extended vacation, that may impact their eligibility for additional TRA. Now, 210 days is, I think, probably about 7 to 9 months. So it's a considerable amount of time that they actually have to submit an application, and you have to do so. And like I said, it's important for additional TRA eligibility. It doesn't mean that if they come in on a 300th day that we would turn them away. It just means that if they came in on a 300th day, that they could still submit an application for training. It's just that they would no longer be eligible for additional TRA. And the reason why that's important is because the worker, when you all go through your training approval process, that the worker has to demonstrate that they will be able to support themselves in the event that TRA is not available. And not having additional TRA may pose a challenge when you are approving applications. Another change under reversion 2021 is that the first payable week of TRA cannot be prior to 60 days from the date the petition is filed. We shouldn't see too many issues with that, but again, the primary takeaway from this is the deadlines have changed from 26 weeks from certification and 26 weeks from separation to 8 weeks from certification and 16 weeks from separation. TRA provisions, there's no earnings disregard under reversion 2021. So, if you are familiar with the earnings disregard, that allows a worker to earn up to their weekly benefit amount without having state law deduction provisions reduce their weekly benefit amount. Under reversion 2021, earnings disregard is not allowed. So state UI deduction provisions will apply like normal. No election provisions. Under previous laws, the worker had a opportunity to elect between TRA and the UI benefit. Under reversion 2021, they no longer have that election option, unfortunately. So those are 2 really big things that will fall under TRA. Not only will the deadlines be reduced, but the earnings disregard as well will change. No good cause. So we have to get them in training on time. Equitable tolling is still available, but equitable tolling is for really egregious cases, really, cases where we, really drop the ball on something. But good cause is for TRA deadlines and training deadlines. Under reversion 2021, the good cause provisions will no longer apply. So if they miss the 16-week deadlines, then unfortunately the only remedy that they may have is the equitable tolling. So it's very important that we get the waiver out before the 16 week, because a good cause would not be there to kind of make up for any our lack in not getting them in training in time. Unfortunately, there's no exceptions for military service. So under the 2015 law and earlier laws, you know that we will toll certain deadlines for military service. And this is, in some cases, has been extended to spouses. So, if you're deployed, if you're the spouse of someone that's been deployed, you will know that we can, and under earlier laws, we can toll certain provisions. You will see that there's no extensions for justifiable cause. You will also see that there's no extensions for judicial or administrative appeals. So with those last three bullet points, under the 2015 law, we just we are able to toll specific deadlines to allow for, life events, being deployed, or judicial, if someone were to appeal their petition being denied, we were able to toll certain deadlines in those circumstances. Under reversion 2021, those are no longer available. Most likely you won't see the final three bullet points, but you are likely to see earnings disregard and the election provisions. Especially with the CARES Act, the election provisions will probably come into play for quite a few workers. But hopefully before that, becomes an issue, hopefully we will have exited reversion and it won't be too big of an issue. So again, just a chart kind of summing up everything. Again, the weeks are the exact same, 65 weeks of additional, but remember you have to have an application filed within 210 days after separation to qualify for additional TRA. They still must be paid. Those 65 weeks must still be paid within the 78-week period. Under 2015 law, you have the election, but under reversion, you do not have the UI TRA election. You also do not have the earnings disregard. 2015 and reversion, there's no remedial weeks. That hasn't been the case since 2009, I believe. Yeah, 2009. So you may see remedial prerequisite TRA weeks, but those are tending to kind of phase out as they kind of came primarily under 2002 and 2009 law. Completion TRA, you still have the 13 weeks of completion TRA. Those are still available. So not too big of a change here. It's just that the election provisions have changed and the earnings disregard has changed. Again, just a brief summary. I won't go over it again. And I believe Susan and Sheila have the slides. So if you want these charts, I believe hopefully they will email them out to you. But the charts are kind of summing up the changes between the laws. So, okay, and we are back to ATAA. So we're going to touch on ATAA. I believe, yeah, so we'll close out with ATAA. We have group eligibility, right? So again, it's a joint process. You don't have to do them separate. The petition and an investigation process will kind of work as one. It cannot be combined with training. With the ATAA, you cannot receive a job search allowance. Okay, so it's important to remember that's a little bit different than RTAA. You can still receive that job search allowance. Under ATAA 618, the new regulations will still apply in how you calculate the annualized separation wage and the annualized reemployment wage. Now, ATAA does expire on June 30th, 2022. And this kind of, again, just highlights that, when Congress passes the Trade Adjustment Reauthorization Act, or the Trade Adjustment Act of 2015. There's just certain provisions in those pieces of legislation that expire on certain dates. It doesn't mean that the program itself expires. It just means that certain benefits or certain services will expire. You may see, we've seen this kind of with HCTC, the healthcare tax credit, within the past few years, that it expires at the end of every calendar year. I believe that's the case as well as this year. And unless Congress renews that specific provision, then that service itself will expire. It doesn't, always mean that the program will expire. So ATAA, it expires on June 20, 2022, unless Congress changes anything. And that requires that a worker must receive their first ATAA payment on or before June 30th, 2020, to retain eligibility for additional ATAA payments past that date. Now, UI eligibility is not a requirement for ATAA. Qualifying employment must be covered employment under the state law, and it must not include activity that is unlawful under federal, state, or local law. So we won't pay a wage subsidy if it is not legal. And the reason, actually, and to kind of go back to that side, there's several states that permit certain types of recreational activities. Illinois is one of them. And with the TAA program, certain types of activities are not still not allowed by federal law. And it's always important to kind of keep that in the front of your mind, especially when approving training plans. There's several training institutions that offer certain types of training for certain types of activities, which are prohibited by federal law, even if they're not prohibited by state law. And the reason why that's important is because if there is a certain type of training plan, or in this case, certain type of employment that is prohibited by federal law, then you cannot approve that benefit or service. So for instance, there's certain types of recreational activity in the state of Illinois, which is permitted by the state at the state level. But if a worker wanted to engage in just hydroponic fertilization, hydroponic agriculture, those types of trainings would be allowed. But if the type of training or the type of employment relates specifically to a certain type of prohibited recreational activity, those types of trainings would not be allowed. So again, when you're looking at those type of activities, especially with ATAA and training plans, just make sure that when you are approving the training plan or the actual wage subsidy, that it doesn't specifically reference any type of activity that is illegal under federal law. If the worker wants to pursue a certain type of training or a certain type of benefit that is allowed, just make sure that it is broad in nature and it does not relate to a specific activity. So administrative provisions, there's no changes to reporting requirements. The PEARL is still required. The PEARL will account for many of the changes under reversion 2021. So it will account for the 8-16-week deadlines. It will account for the waivers. It will account for all of the changes that are happening under reversion 2021. The state does not need to adjust. Well, you need to adjust what is reported, but you will not need to adjust how you report. The system will be able to accommodate that. So changes to overpayment provisions. It removes the military service exception. And again, good cause is not allowed, which deals with TRA and training deadlines. However, equitable tolling is still allowed. And equitable tolling just means that that we really messed up. There was an egregious mistake. Overpayments, it reverts to that the state may waive instead of shall waive. So under reversion 2021, the state has a discretion on whether or not they may waive an overpayment. Under earlier laws, there are certain provisions that require a state to waive, that they must waive if the overpayment will be contrary to equity and good conscience. All right. So it just wouldn't be essentially fair to continue with the overpayment. Under reversion 2021, the state has an election to waive under earlier laws. If it would be contrary to equity and good conscience, essentially not fair, then the state is required to waive that overpayment. Funding and allowable costs. So this is what we will close out on. Funding and allowable costs. The cap is reduced to $220 million. This is still more than enough to place thousands of individuals into a suitable training plan. So please do not hesitate to continue with your practice as normal as placing individuals into a quality training plan. There's plenty of funding to do so. The only changes in funding that will have a considerable impact on you deals with the case management funding as far as kind of servicing an individual. But that, again, that doesn't apply to your initial assessment. So depending on what your initial assessment entails, again, there's funding available for that initial assessment, and the state may want to review how comprehensive that initial assessment is and try to gather as much detail as possible under that initial assessment, since that is where funds are still allowed. Administrative costs, they're still determined by ETA. Unless Congress changes anything in the budget. But again, the funding, the really big impact for funding will just impact you primarily at the case management level, but there's still considerable funding to place an individual into very, very quality training plan. So don't hesitate in doing that. Again, kind of a chart you'll see with the 2015 law, the amount reduced from $450 to $220 million. Illinois, I believe, is 3 or 4 in the list as far as annual funding for the region. So the state has a considerable amount of activity. Case management funding, you will see again that the change just deals with the, you still have access to case management funding for the initial assessment. Okay. So closing out, this is kind of just a overarching chart that kind of sums up pretty much everything that we've kind of talked about. You'll see that service sector workers are not eligible. This may present some issues as, in recent years, we've certified many service sector workers, call centers, accountants, attorneys, sometimes even English as a second language may be impacted by foreign trade. So it's important to remember, though, that if it is a if it is a service sector worker under reversion 2021, they would most likely not be allowed under or not be certified. But this still should not discourage you from filing a petition because, as I mentioned earlier, with the previous reversion, we were able to retroactively go back and reconsider denied petitions. So you want to make sure that you continue to file any petition that you believe is impacted by foreign trade, because it may be able to be retroactively considered, and depending on what Congress changes, it may require that it have been filed in a certain time period. So please continue to file the petitions. Here are our resources. Again, this presentation was kind of based on TEGL 2420, which is kind of the basis of reversion 2021. We always have our TAA program website. We have 10.1.21, which is an FAQ document. Very beneficial if you want to go and take a look at that. And we always have Susan, Sheila, and myself if you have any questions. So that is the presentation. Thank you for kind of walking through this with me. Again, you should have some comfort in knowing that this is my first reversion as well. So if you have questions, please send them to the state and they will get them to me eventually, because it will only help me kind of dig a little bit deeper into reversion. So With that being said, again, thank you all for kind of working through this with me today, and I will turn it back over to Susan and Sheila.
Thank you so much, Jason. Thank you very much. We'll stay on for a couple seconds if anybody wants to type any more questions in there. Otherwise, like Jason has said all along, feel free to email us, and if it's not a specific to your local area question, we will be sure to share that with everybody and keep this going. Again, we'll have some training in August that will go over some stuff. We're tweaking some forms and processes and stuff like that, and working with IDS on how to represent the part-time training and that type of thing, so that we can still report them as part-time as we're required to do, but yet they'll still get TRA. So we're still working on that.
Yeah, and we will send link out to the recorded presentation and also the slides later today, as soon as David gets me the link for the recording. And we'll make sure everybody has those.
Everybody give virtual clap to Jason.
Yay!
Snaps.
Good job, Jason.
Thank you.
Thank you. Thank you again. So I will hopefully see you all at a roundtable soon. I think that's all you need from me today, right? Or
I think so. Everybody's just saying thanks in the chat, so I don't think we have any other questions at this point.
okay. All right. Well, take care.
Thanks everyone for joining.
Thank you so much.
Okay. All right. Bye-bye.
Yes, thank you. Yay.